Hey, it's Candice Quinn, and I'm here today to talk to you all about bankruptcy. I know it's not the most interesting topic, but it is one that I truly believe every attorney should have a general working knowledge of. It comes up in so many different areas, from litigation to mergers and acquisitions, and it's really important to understand the basics so that you don't look like a fool in front of your clients. So, what is bankruptcy really? Well, bankruptcy is a process through which individuals or businesses can get relief from their debts. It's governed by federal law and actually provided through the Constitution, and all of it happens in federal court. Now, there are different chapters of bankruptcy, and they all work very differently depending on whether you're an individual or a business and what type of bankruptcy you need to file. Whether you're dealing with a person or a business, the goal is to wipe out debt either through reorganization or liquidation. There's three main bankruptcy chapters that every attorney should know: Chapter 7, Chapter 11, and Chapter 13. Starting with Chapter 7, this is the chapter that everyone thinks of when they think of bankruptcy generally. This is an individual bankruptcy chapter, and it addresses liquidation. So for consumers, this means that you are going to discharge most of your debt. This is typically for individuals with very minimal assets and very high levels of debt. Things like medical debt or a foreclosure where they don't want to retain the house. It can also include credit cards and personal loans as well. Now, the general concept is that a trustee comes in and takes over basically all of the assets of the individual and can sell off the non-exempt portion of the assets to satisfy the individual's debt. But the reality is that people that file Chapter 7 don't actually have any assets that aren't exempt. So most of the time, the trustee is just confirming that the assets of the individual are exempt, and then after a waiting period, the debts will be discharged. Exemptions protect things like your retirement, your home equity up to a certain amount, your car up to a certain amount, and basic household items. Now, businesses can also file Chapter 7, and if they do that, it is a straight liquidation. Again, they probably don't have many assets if they're filing a Chapter 7, but this does see more distribution of assets than an individual Chapter 7. As an attorney, if you're helping a client file a Chapter 7, you're advising them on whether they can keep assets and which ones they can keep and which ones they can't. You're even helping them determine if they qualify for a Chapter 7. There is a small means test that they need to take in order to know if they qualify or not for a Chapter 7. If they have too much money or too many assets, they may not qualify and may have to do a Chapter 13. So let's look at a Chapter 13. Chapter 13 is just for individuals, and it is a reorganization. So the individual is going to file a bankruptcy. They're going to file a plan with the court to show how they will repay a portion of their debt. This period of repayment will be 3 to 5 years, depending on the situation. And the individual, if the plan is approved, will make monthly payments for the 3 to 5 years. And once that is complete, they will have a discharge of the remainder of their debts. Certain debts can be assumed, so things like a house and a car, you can make the regular monthly payments during the plan and continue those payments thereafter without any loss of the house or the car. The individual makes the monthly payments to the trustee, and the trustee in turn distributes them among the creditors, typically at a pro rata share. So your medical debt, your credit cards, your personal debt, anything that is unsecured or not backed up by an asset will be a pro rata distribution. The most common reason to do a Chapter 13 is to retain your primary house. If you have more equity in your home than is exempt under the bankruptcy code, then you will do a Chapter 13 so that you can keep your home. If you're the attorney representing the individual, you are helping them draft the plan, and you're making sure that it aligns with the trustee and the judge's standards in that specific geographic area. Chapter 11 is just for businesses, primarily, and it is just like a Chapter 13, it's a reorganization. There are some limited circumstances where an individual can file a Chapter 11 to reorganize, but that is for very high net worth, high income individuals. In this case, the business is going to keep operating basically in normal course under the Chapter 11. They will have to do things like open new bank accounts and get court approval to continue paying employees or paying critical vendors, things like that. So it is very fast paced, especially at the beginning, because there will be a lot of first day motions and things that need to happen immediately so that there's no disruption to the business. We all know this from airlines and retail chains who are filing Chapter 11 all of the time. For attorneys and law clerks and judges, Chapter 11 is very intense. Like I mentioned, there's a lot of first day motions that need to happen in order to keep the business moving, employees paid, etc. But there's also a lot of hearings, a lot of things drag out. There's a lot of different committees that get formed to represent the unsecured creditors, the secured creditors, etc. There's a lot of negotiation. There's typically might be a buyer coming in to fund the ongoing business, and all of this takes a lot of time. Okay, so moving away from the different chapters, there's some key concepts of bankruptcy that every lawyer should understand. The first of which is the automatic stay. This is one of the most powerful tools in bankruptcy because the minute anyone files bankruptcy, it stops creditors from contacting or otherwise attempting to collect the debt from the individual or business that filed. This stops lawsuits, foreclosures, wage garnishments, you name it, everything is stayed while the bankruptcy takes its course. The idea is that your client will have breathing room to figure out the best course of action rather than just an emergency course of action. It's not permanent though, and creditors can file motions to lift the automatic stay if there is a extenuating circumstance or your client has done something wrong like fraud or is not making post-petition mortgage payments, car payments, things like that. So far, I've been talking about representing the bankrupt individual or business, but there's also a lot of representation that attorneys do on behalf of creditors. So when you're representing creditors, your job is completely different than when you're representing the bankrupt person or business. You're going to be focused on getting as much money as you can for the creditor that you represent, whether that's the mortgage company, the car note holder, or even just a credit card. You are going to be focused on whether or not they're going to get their fair share of the debtor's estate or not. You may be looking through credit card statements to find out if they committed any fraud and filing an objection on that basis, or you might be looking for things that are wrong in their plan and objecting to the confirmation of their plan. You also can argue that things like student loans and taxes are not dischargeable at all, meaning that the debtor will have to keep paying them even after the bankruptcy. And finally, and probably most importantly, you're also looking at whether the debtor is still holding on to assets or hiding assets that would otherwise be included in the bankruptcy. Now, I've mentioned the different types of creditors. There is a priority of creditors within a bankruptcy. Creditors that have security of an asset are going to come before an unsecured creditor like a credit card or medical debt. This actually can get quite complex and very complicated very quickly. So it's always a good idea to make sure you understand exactly where your creditor client stands in this hierarchy. So now let's talk about what the difference is between discharge and dismissal. So a discharge is whenever the debtor is relieved of their debts. So this typically happens in a Chapter 7 or it typically happens in a 13 after completion of the payment plan. It does not happen in a Chapter 11 because it is a reorganization. When the debtor gets a discharge, it means any of the discharge debts are wiped out. They legally cannot be collected anymore. They can't be listed on the credit report unless they're listed as discharged. They are just done. This is the ultimate relief for a debtor. This is what they wanted to accomplish by filing bankruptcy. A dismissal, on the other hand, means that either the debtor failed to do something, something went wrong, or the debtor just changed their mind, and the bankruptcy court just dismissed the case. They threw the case out without granting the debtor any relief of their debts. So it seems like you wouldn't want a dismissal, but there are certain strategic times where a dismissal is not bad. What you don't want to get is a dismissal with prejudice, because that means they cannot file bankruptcy again for a certain number of days, which is typically stated in that dismissal order. Now, if you're not a bankruptcy attorney, I don't recommend just dabbling in it, but I do recommend understanding the basics of it and knowing who you can reach out to for more help if you need it. If you're ever advising a client that's considering filing a bankruptcy, go ahead and just refer them to a bankruptcy attorney. That is the best bet for you to avoid a malpractice claim. But you want to have an understanding of the basics so that you can give them some basic knowledge before they head to their meeting with the referred attorney. So you can tell them what types of paperwork they need to bring, what types of things they need to ask, and you can give them some basic information so they have an understanding of maybe they're thinking of a 7 or maybe they're thinking of a 13. They can basically understand what they might need to do. And if you're on the business side, well, you definitely want to bring in a business bankruptcy attorney. It's a completely different area than an individual consumer bankruptcy, so it really is its own niche and does require its own set of expertise. If you represent the creditor, the first thing you need to do is make sure you get the proof of claim filed on time. If you miss the deadline, then you might not get paid on your claim at all, and there's probably nothing that you can do about it. Bankruptcy isn't as scary as it seems to be, though there is a lot of moving parts and a lot to know. Knowing the basics makes you a better attorney, but remember, don't dabble in something that you don't have expert knowledge in. And if you did fall asleep in bankruptcy class, well, I hope you were awake for this reminder. If there's another topic that you want me to cover in the If You Fell Asleep in This Class series, go ahead and drop that in the comments below. I'm happy to go through that for you. And if you'd just like to schedule a call to discuss your career with me, go ahead and hit the link in the pinned comment and the description below. I'm happy to have a free call with you. Bye for now, hackers.